Hello, welcome back once again for part 2 of the application for judicial review. So in the last class, we stopped at two of the prerequisites. Correct me if I'm wrong. The first would be the locus standi, right? And the second would be exhaustion of all remedies, right? Before taking an action by way of judicial review application, right? And we stopped this slide on the definition of a victim. And the definition of a victim would be important in which kind of cases? In cases involving human rights. Okay, so think about the prerequisites that you have already learned as we go on to the other prerequisites that you have before you apply for judicial review. So it is not that easy to make that application for judicial review. As we go along, you will realize that sometimes claimants might shy away from a judicial review application and rather go by civil law suit or procedure, but that may not be ideal, right, for the party, for yourself, and naturally for the local authority. The local authority can easily get away if it's a situation whereby you have used the wrong procedure. Okay, so the next part, which is important, is whether or not you are amenable to judicial review. Is the matter such that it is amenable to judicial review? All right, so what does that mean? The claim to review the lawfulness, basically what you're doing is you're claiming that either an enactment or a decision or action or failure of the executive allows you to make this application for judicial review, all right? So there must be a reason behind it, and the reason has got to do with the authorities, right? Either the law that is made is not right, it's not legal, or the decision that has been made by virtue of a law is not proper, right? So then only you're amenable. Okay, so if it is by way of contract, for example, you have there is a particular authority that has power because of a contract and not because of an act of parliament. The power doesn't come from statute or royal prerogative. Then the matter does not come within the purview of judicial review application. Of course, you can sue. In other ways, you can sue, because as you know, the Crown can be sued, right? However, it doesn't come under judicial review. Okay, so when we look at the case of CCSU, and you've looked at this in the past and you'll be looking at it again, this is a very important case, CCSU's case. Basically here it tells you the test of existence of a public law duty. As per Lord Diplock, decision maker empowered by public law to make decisions that would lead to administrative action or abstention from action, ultimate source of power being a statute, subordinate legislation, or prerogative. So what does that mean? It means that you are scrutinizing the action, abstention of action, decision of a public authority that has been made under the authority of or under the power of either a statute, a delegated legislation, or if you cannot find where it is, it's probably by way of royal prerogative. Okay, so this is basically how we look at amenability. So the source of power test is important, right? The source of power. Where does that public authority have power from? Where is it coming from? So in English court, there was a long-standing test that considers the source of power to determine whether a body was public or private, right? So generally, bodies exercising statutory or prerogative powers would be regarded as public bodies. So they will be amenable to judicial review, all right? But if it's an authority exercising power granted under contract, then not amenable to judicial review. Okay, so that is how we look at it, right? However, there are many restrictions that the judges have held to the traditional view that the public law body was one created by statute or under prerogative. Okay, so there are other limitations as well, right? When we look at this, so it's not that easy to take a local authority or a public authority to court and say that, a judicial review application needs to be made, a decision has to be reviewed. It takes a while. You have to note the source of power. The lawyer has to be clear as to where the source of power is coming from. Okay, sometimes it's not very clear, like in the case of ex parte hook. Okay, here the applicant applied to have the decision of the local council to exclude him from trading in the market and to revoke his right to have the stall quashed, right? So basically, here his license was revoked and he wanted that decision to be quashed, right? Find out for yourself, why is it his license was revoked? Interesting case, we'll be looking at that later on. So it was held that he succeeded on the grounds that the decision had been taken in breach of the rules of what? Natural justice. So the right of a stallholder to have access to the market was conferred by common law and could only be taken away for just cause, and then only in accordance with the principles of natural justice. So here you see the source of power is a little bit different. The source of power here is under common law. He had the common law right to go to the market to buy and sell. Obviously, there was also a statute involved here, the Barnsley Corporation Act of 1969, which gives the authority basically within the vicinity. And basically what happened here was he was under an oral license from the borough council, okay, to operate his business. And that license was terminated by a letter from the market manager. So the question was whether or not that was an appropriate exercise of authority. So sometimes the source of power can be found from common law as well. His rights can be found from common law as well, right? But technically, of course, when we look at the power itself, we are looking at it in terms of the power coming from a statute, the power coming from royal prerogative, the power coming from delegated legislation. Okay, but in terms of the rights of an individual, the rights of the individual can come from common law, right? So here he had that common law right to go to the market to buy and sell. Okay. Next. Now, apart from all the criteria that we've learned earlier on, you also need to realize that in this day and age, the public authority is not the only one acting in a public manner, right? You have instances where, for example, health comes within the public domain. It is the government that provides, that security, provides healthcare for its citizens. However, you also have private hospitals. Okay, so sometimes it can be confusing whether a matter comes within the public domain or the private domain. So, for example, education. Education generally in this country is public, but then you also have private schools, you also have private universities. So, does that come under the public domain or the private domain? Again, issues like this do arise, correct? So, there is a test that can be employed. If you look at the case of ex parte debtor fin, that's the case that gives you that test. So here what Lord Justice Lloyd stated was that for the most part, the source of the power will be decisive. So if the power comes from a statute, if the power comes from delegated legislation, the discretionary power, then that should be decisive. Accordingly, if a body is set up under statute or by delegated legislation, then the source of the power brings the body within the scope of judicial review. However, the eminent judge continued, he also recognized that in some cases the matter would be unclear. Where that situation existed, it was necessary to look beyond the source of power and consider the nature of the power. Got it? So sometimes you cannot just look at the statute. Statute not enough, doesn't give you enough information. So you look at the nature of the power. If the body in question is exercising public law functions, or if the exercise of its functions have got public law consequences, then that may be sufficient to bring the body within the reach of judicial review. You see? So sometimes it's not very clear. So here, basically, here it had got to do with a takeover panel, okay, that dismissed a complaint made by a bidder in concert, contrary to the rules on takeover. So the bidder applied for judicial review. It had got to do with the city panel on takeover and mergers, takeovers and mergers. Their decision seemed to be contrary to the rules of the takeover. So the issue is, when it comes to taking over of companies, things like that, does it come under, does it come under public law or private law? Does that authority actually have public law functions or private law functions? Or, there's what they do have public law consequences. This is the thing that you have to figure out, right? When it comes to amenability to judicial review, who exactly is a public authority? Sometimes it's pretty clear, okay? Like in the case of ex parte Aga Khan. Now, what happened here was Aga Khan sought judicial review, right, of a jockey club's decision to disqualify his winning horse because the horse failed a dope test. And the relationship between the racehorse owners and the club was basically derived by an agreement between the parties. So if it's derived by an agreement, if it's not by statute or by delegated legislation, then probably it is a matter of private, not public law. Okay, so if you look at Section 6 of the Human Rights Act as well, public authorities are defined to include courts and tribunals and any person, certain of whose functions are functions of a public nature. All right, so that similar kind of definition is given in Section 6 of the Human Rights Act. Again, another case on racehorse, another case on jockey clubs, okay? The case of law. The plaintiff alleged abuse of the discretion conferred on the club by the rules. The trainer's license had been suspended. He said that it was contrary to an implied agreement, term of the agreement between the trainer and the racing club, that any action taken would be reasonable and fair and made on reasonable grounds. Okay, so the plaintiff claimed a declaration of the invalidity of the decision. The question before the court was whether a special procedure or the special procedures which Order 53 of the rules of the Supreme Court, all right, at that point of time, apply to the applications for judicial review should have been followed. Okay, so again, situation of whether it's public or private. And basically here it was held, the power of the stewards of the respondent racing club to impose penalties for breach of the rules on owners of greyhounds derives from a contract. Okay, so the moment it derives from a contract, then basically it comes within, basic civil law action and not judicial review application. Okay, so again, another case on a racing club, that those kind of things would come under private law action. Okay, so apart from public authority, there is also this concept of exclusivity. Okay, at this point of time where we hope that everything is inclusive, there is this one principle of exclusivity. Now, why the judges have this principle of exclusivity? Probably because there is a need to, keep things clear and keep things simple for the judges as well. right? Because everything comes to their courts, they will not be able to handle. They will not have the expertise to handle everything that comes to court as well. A jack of all trades is basically a master of none, right? So there is a need for exclusivity in some instances, right? So let's look at this concept. What does it actually mean? Now, basically, before 1978, all these prerogative remedies had issues. They were difficult. They had their own procedure, could not be combined with applications for other remedies. It was difficult to go by a prerogative remedy. What are the prerogative remedies? We'll do that later when we look at remedies per se in the next lecture, right? So post 1978, application for judicial review where applicant can seek one or more or any 5 remedies, it was made simpler. Okay, and this led to the reform to the Supreme Court, now senior court rules, all that have changed, right? But there was a need also to change things in terms of or to provide some clarity in terms of an application for judicial review. Okay. Now, what are the rules of the Supreme Court? You see, look at that. Order 53 of the rules of the Supreme Court. The rules of the Supreme Court basically was superseded by the civil procedure rules. Okay. Civil procedure rules in 1999. Right. So anything before 1999, it was called the rules of the Supreme Court. Right? Just to clarify, yeah. So what does the exclusivity principle mean? Now, this is a decision of 1983, which some people may not agree with today, but we still apply it. So the issue for the court was whether it was an abuse of the process of the court to use the alternative basis to bring the action. Okay. So what happened here was this case concerned prisoners whose remission had been forfeited, right? So they were not remitted. Okay, they were not allowed a lesser sentence, a shorter sentence. So they commenced proceedings by way of writ. Now, writ is a civil law procedure. Okay, so the House of Lords held that the prisoners did not have any private law rights. The only rights lay in public law, and any action should have been commenced by way of judicial review. Okay, so this is what Lord Diplock had to say. Okay, and this is where you have the issue that arises really. If what would emerge is that his complaint is not of an infringement of any of his rights that are entitled to protection in public law, but maybe an infringement of his rights in private law, and this is not a proper subject for judicial review, the court has the power under Rule 9, sub 5, instead of refusing the application, to order proceedings to continue as if it had begun by writ. Is that clear? Is that clear? Look at it again, read it again, and try to understand this. Basically, what is being said here is, it's a public law action. It's a private law action. It's a private law action, but you made an public law application. Okay, so if it's a private law action, but you made a public law application, then just continue like as if it had begun by writ. Okay, just continue like as if it had begun by private law action. Okay, so when it's public to private, it's different. Private to public, it's different. Okay, let me make this clearer with the next slide. Maybe this will be clearer. Okay, so Lord Diplock went on to state now that those advantages to the applicants have been removed and all remedies for infringement of the rights protected by public law can be obtained upon the application for judicial review, as also can remedies for infringements of rights under private law. If such infringement should also be involved, it would be in the view of the general rule, be contrary to public policy, and as such, an abuse of the process of the court to permit a person seeking to establish that a decision of a public authority infringed rights to which he was entitled to protection under public law to proceed by way of ordinary action, and by this means evade the provisions of Order 53 for the protection of such authorities. Got it? Okay, so private law action, but you begin by public law. Never mind, the courts will say, never mind, because just small mistake, we can continue like, it's done by like a private law action. But a public law matter, you start it off like as if you start off a civil private law matter by writ. The court will say, haha, you are trying to evade the process. It is an abuse of the process of the court. Okay, because it's harder to make that application for judicial review. So maybe you're trying to just get the easy way out by going by writ. Okay, because then all the criteria of judicial review application need not be met. That is what the court is saying here. But the thing is, a lot of things have changed over the years, right? A lot of matters you're not sure whether it's public or private, because the government is also involved in private matters, government is also involved in public, private entities are involved in public matters. So it's quite confusing today to have this exclusivity. Nevertheless, it is still there. Okay, still there. So the decision in O'Reilly has been criticized, obviously. The exclusivity principle, keeping public and private law rigidly distinct, that was introduced in O'Reilly, okay, were not intended to create rigid distinctions, according to Professor Wade. Okay, it's not meant to do this, where it's so distinct and then your case will be struck off if you use the wrong application. Sometimes it's quite difficult to make those decisions. So it seemed a little bit too rigid, right? However, it is practical. It's practical for the judges. But you have situations where, exceptions apply. Naturally, in every general rule, there will be exceptions, right? So the harshness with which the exclusivity principle could operate led Lord de Block in O'Reilly to state that exceptions to the rule would exist where the case involved both public and private elements, particularly where the public law element was collateral to the private law element. So if the public law part of it is just a small part, collateral too. If it's the primary part, then you go by public law application. But if it's just collateral too, then probably if you start by private proceedings, it's fine. Okay, so this was the exception that was given. There are other exceptions as well. First of all, if the public law issue is actually just a defense, like in the case of Winder, the House of Lords allowed a matter of public law, lawfulness of the council's decision, to be used as a defense to private law proceedings. Here it was possession proceedings. So basically what happened here was Winder was a tenant of the local authority, and the local authority gave notice that rents were to be raised. And Winder tried to claim that, this was unreasonable, this was contrary to law to have the rents raised in this way. And the local authority brought an action for possession of the premises, right? So that is a private law action. But there was a defense that was public in nature, the council's decision. You see, so it's got two elements in it, public and private. But in this case, it was decided private is fine because, possession, that is the main thing. Possession of the house, possession proceedings is the main thing, right? So that would be private in nature. Another case involving both private and public, important case here, work with the NHS. Okay, NHS work is a hot topic at this point of time. If you are forced to work, if you've already retired and you've been called back to work with the NHS because of, say, a deadly virus like COVID-19, for example, I know, are you compelled to go back to work? A lot of issues arise here, a lot of issues with doctors, health workers in the UK, yeah, with regards to the NHS. So this it's got nothing to do with COVID-19. This is an old case, but a further exception was given in this case to the exclusivity principle, whereby the House of Lords ruled that the principle did not apply where the proceedings involve matters of both public and private law. Okay, so you've got both there, then it's probably going to be something that if you start by private or public, it doesn't matter. So here Roy was basically trying to say that the Family Practitioner Committee was responsible for making payments, right, to general practitioners in respect of their NHS work. And Dr. Roy's allowance was reduced by the committee on the basis that he had reduced the amount of time spent on NHS work, right? So here it's both private and public. Okay, so he still had the right to private law remedies because, you know, NHS work, no doubt, is a public authority, so to speak, but nevertheless, it is also a contract that he got himself into. Okay, so you've got both private and public elements. Another case on private and public elements, this case is very important because it tells you what you need to do, okay, in this situation. And it tells you that, you know, the court shouldn't be overly concerned with the distinction of private and public. Look at the practical consequences. Okay, be a bit more practical in the approach. That's what this decision basically states. And Lord Wolf, after consideration of these other cases of, you know, O'Reilly as well as Roy, Kensington and Chelsea and Westminster Family Practitioner Committee, ruled that as a general rule, it is contrary to public policy and as a result an abuse of the process of the court to permit a person seeking to establish the decision of public authority infringed rights to which he was entitled to protection under public law to proceed by ordinary action. So he agrees with O'Reilly. He does agree with O'Reilly. So what actually happened in this case? First, we look at the facts and then we look at the guidelines, you know, some guidelines that were given in this case. So what happened here was the plaintiffs required by local authority to carry out repairs on certain houses, okay, to make them fit for human habitation. And so the plaintiffs applied for improvement grants from the council under the Local Government and Housing Act. Okay, so when the work was completed, the council refused to pay the grant on the basis that repairs were not carried out properly. So the plaintiff commenced private law proceedings to recover the money due. The council complained that this should go by way of judicial review application because local authority, local council. Okay, so the issue is whether or not in such circumstances it should go by private law action or public law action. Here the Court of Appeal refused to strike out the case, even though the council complained that it was an abuse of the process of the court. So it was a case that involved both public and private law issues, and Lord Wolf gave some pragmatic suggestions. First of all, Lord Wolf said, if it is not clear whether judicial review or an ordinary action is the correct procedure, better to go by judicial review application. Okay, so as a lawyer, that would be the best approach, because if you go by judicial review application, nothing gets struck off. You just start off as if it began by writ. It doesn't waste time, right? Now, if a case is brought by an ordinary action and there is an application to strike out the case, that's the second point. The court should at least, if it is unclear whether the case should have been brought by judicial review, ask itself whether if the case had been brought by judicial review when the action was commenced, it is clear leave would have been granted. If it would, then that is at least an indication that there has been no harm to the interests of judicial review to the interest that judicial review is designed to protect. Okay, so look at the case objectively. If it is a case where anyway leave will be granted, then obviously there's no real abuse of the process of the court, right? It's just a mistake, right? It's just a different channel. So here is a little bit more pragmatic, a little bit more practical. Okay. Finally, in cases where it is unclear, okay, where the proceedings is correctly positioned, placed, it should be remembered that after consulting the Crown Office, the case can always be transferred to the Crown Office list as an alternative to it being struck off. So quickly transfer it. Okay, transfer it to a public list so that it becomes a matter for judicial review application. So these are the suggestions, pragmatic suggestions that were given by Lord Wolfe. All right. So this sort of assists lawyers in making their decision. Always better to go by judicial review application if you're not sure, right? However, sometimes the situation is such that it's not that you're not sure, but perhaps you've run out of time. Remember, timeline is 3 months. That limit for judicial review is very short. What if you have, exceeded that limit? So here is a case which is quite interesting, where a more liberal approach was employed in the case of Clark and University of Lincolnshire and Humberside, in which a student sued her university for breach of contract after having been failed in her examination following unproven allegations of plagiarism. Okay, so she went by a suit. She didn't go by judicial review application. Why? Because she was out of time, right? So the Court of Appeal disagreed, right, that it was inappropriate for her to go by civil suit application, stating that the claim would not be struck out on the basis that the applicant had proceeded under contract rather than judicial review. Okay, so sometimes the courts are liberal and will look at it in terms of a private law action rather than judicial review application. Okay, so you find that this is interesting to note. This is interesting to note in the sense that even though the substance education is public, but still it was acceptable to go by way of private law action. Okay. So with that, we have completed all the prerequisites, what you need in making the application for judicial review, right? In the next class, we will be looking at the remedies, okay? What can you actually get out of a judicial review application, okay? And then we will go into the substance of judicial review. Okay, so go through the slides again, have a look at these cases, have a look at the textbooks to give you an idea of how judicial review actually works. It's not so straightforward, obviously, it's quite complex. It's dependent on judges. Judicial interpretative techniques is important here. So you need to understand how these things work. All right, so with that, we close this particular topic. We will see you soon for the next topic. Bye-bye.